Hi, everybody. Welcome to Couch Counsel. My name is Jaime Wisegarver, and I'm here with my partner, Andy Sherrod. And today we're going to be talking about Virginia's new marijuana laws. So, Andy, jumping right in, what do employers need to know about the new marijuana laws in Virginia?
Yeah, Jamie, this has been a really hot topic. Been getting a lot of questions on this one. The big new law that was passed this summer went into effect in July. Legalizes possession of small amounts of marijuana by folks over 21. That's the one that got most of the publicity. There are no employment protections baked into that law, so folks that take advantage of this new ability under Virginia law to smoke marijuana, they could suffer the consequences from an employment perspective. The more significant law that companies need to be aware of that also passed this summer, also went into effect in July, covers Virginia's medical cannabis oil statute, which was a program that was already on the books. And it does provide some employment protections for folks that are certified medical cannabis oil users. But importantly, number one, it's very narrow. It only applies to the cannabis oil, not to other uses of medical marijuana or marijuana for medical purposes. It only applies to cannabis oil. Number two, there are some specific carve-outs to the law. So it doesn't protect folks from being impaired in the workplace. You can still take disciplinary action against cannabis oil users in that situation. Also, you can take adverse action against cannabis oil users if it would cause your company to run afoul of federal law or violate a federal contract that you have. So those are two important carve-outs to this new Virginia statute. Jamie, those are the two big laws that folks are dealing with. What else do people need to worry about?
Yeah, one other worth mentioning, Andy, is Virginia's new ban the box law. This prohibits employers from requiring job applicants to disclose information about an arrest or a criminal charge or a conviction for the simple possession of marijuana. The statute also gives applicants the right to just refuse to answer those types of questions and to refuse to provide any information regarding those kinds of arrests or charges or convictions. Importantly, Andy, employers are subject to criminal penalties if they willfully violate that new law. And so I would recommend that employers really take a hard look at their job applications and their hiring practices to make sure that there's nothing that's in violation of that ban the box law, and that they're not requiring applicants to disclose any sort of marijuana possession arrests or charges or convictions. So Andy, we've touched on a few different changes to the laws here. What do you think is going to be the practical impact of these new marijuana laws on employers in Virginia?
Yeah, Jamie, I would say that one's going to be evolving, and it's going to be one that, employers just really need to keep their finger on the pulse of what's going on, because I think that, the trend here is just to provide more and more rights to use marijuana, and probably more and more protections for folks that do. Right now, certainly you want to make sure that your policy is reflective of these new Virginia laws. That's the starting point. I think also, employers should really take a fresh look at their drug testing programs to make sure that, they are meeting the purpose for which they were implemented. A lot of folks have a misconception that the Drug-Free Workplace Act requires drug testing, and it actually doesn't in most situations. And so, folks should think about whether, it makes sense to continue testing for marijuana. It very well might, but in certain situations, maybe it doesn't, because, with these new laws on the books and more legalization, you might have more folks that are using marijuana outside of the workplace, and you might have, a limiting effect on your applicant pool if you are, implementing a pre-hire, marijuana testing regime, or you might have a situation where you could have a good solid employee who tests positive on a random test. And then what do you do? And if you have a zero tolerance program, Do you make an exception for that person, but maybe not for another person? That could get you into some hot water potentially on a, a discrimination claim, for example. So I would just say, think long and hard and consult counsel on, what the best approach to your drug testing program might be. Also, I would say, keep an eye on accommodations. Obviously, marijuana is still illegal under federal law. It's not protected under the ADA from a reasonable accommodation analysis perspective, but got to remember there's Virginia state disability laws, and those also require reasonable accommodations. And what needs to be done with folks that might request an accommodation for use of medical cannabis oil. That's not addressed in this new law, and so it's certainly a gray area, but it's something that folks need to think about, whether that's going to be something that they would allow as an accommodation under the particular circumstances. But I would recommend that folks certainly seek counsel if that issue comes up.
Very sound advice. Thanks, Andy. To our viewers, if you have any questions about Virginia's new marijuana laws, please don't hesitate to reach out to Andy or myself at Hirschler. And thanks for watching.